Now please welcome Mr. David Hansma, who is going to address the nuances of privilege and its application in shareholder oppression cases. Mr. Hansma, you have the floor.
Thank you very much. Thank you everyone for being here this afternoon. I am going to attempt to share my screen and control my PowerPoint myself. So your prayers are appreciated as I try and do that. God willing, you're seeing what I'm seeing. Tonight, I'm going to be talking about attorney-client privilege in shareholder oppression cases or shareholder cases in general. Mark's summary is at the beginning is pretty close to what I'm going to be talking about. We're really going to be looking at this from the defense side of things. Plaintiff side, plaintiff goes out, hires an attorney to sue and bring a shareholder oppression action. His communications with his attorney, not a lot of controversy there with respect to the attorney-client privilege, but on the defense/management side, there is a little bit more nuance to it because the plaintiff quite often has a certain amount of rights to information about what's going on with the company and the management of the company, especially if the plaintiff is also a director, which in closely held companies is quite often the case. So the question comes up as to how much access to information are they allowed to have if that's going to invade the attorney-client privilege that the defense/management has with their attorney. So with that, we're going to start with Delaware because a lot of corporate issues start in Delaware, though there is some question in the case law whether or not this is really a corporate issue or is it just a straight attorney-client privilege issue. But we're going to start with Delaware, and we're going to talk about directors first, and particularly where your communications are with where your plaintiff is a former director of the firm or the company and is trying to get access to attorney-client privilege information that occurred during the period when he was a director. And there's kind of this leading case, it's Kirby versus Kirby out of Delaware. There, the plaintiffs and the defendant were all directors of a nonprofit organization. The defendant threw the plaintiffs off the board. There was litigation. The plaintiff sought discovery of communications between the defendant and the foundation's attorney. And they saw communications that occurred during the period when they were on the board and during the period after they got thrown off from the board. And the court held, the issue comes down to who is the client. Is the corporation the client, or are the directors collectively the client? And the court held that the directors collectively should be treated as the joint client when legal advice is rendered, so that one director is entitled to all of the information that any other director is entitled to, and the directors can't assert the attorney-client privilege against each other. And that is still the rule in Delaware. I cited a case kind of on the bottom of the screen there, which is a more recent case, has the general rule that a corporation cannot assert the privilege to deny a director access to legal advice furnished to the board during the director's tenure. And that's going to, we're going to see in a couple of minutes, how do we deal with that then if your director is still, or if your plaintiff in the case is still currently a director? What right of access do they have to invade the attorney-client privilege with respect to the ongoing litigation? But before we get there, we're going to just touch briefly on the other aspect of the Kirby case, because the plaintiff there also sought information about communications that occurred after they had been thrown off the board. And there was the case was about whether or not they were still directors or whether or not they were no longer directors. And because they weren't actively involved, the court decided to treat them by analogy to shareholders bringing a derivative claim, and applied the rule of Garner versus Wolfenbarger, which is a decision we're going to talk about more in a couple of minutes. But Garner, the upshot of which, sort of a preview of coming attractions, is that plaintiffs, at least in a derivative case, can show, quote, good cause to discover attorney-client communications. And we're going to see how that plays out. But staying on directors for a minute, not everyone agrees with the Kirby analysis. Milroy versus Hansen is kind of a well-known case that dissents from the Kirby analysis. It was decided, 7-8 years after Kirby. And that decision, relying primarily on US Supreme Court holdings, said that there's no such thing as a collective corporate client, that the issue with the attorney-client privilege is who is the management of the company. And as people leave management and come into management, their right to access to attorney-client information, they either gain that right when they step into management, or once they step out of a management role, their right to attorney-client information goes away completely. So there's only one client, it's the corporation, and only the management has access to attorney-client information. And a dissident director is by definition not management, and therefore isn't allowed to pierce the attorney-client privilege when the current management doesn't want them to. If the current management says, no, you're not going to get that information, they're not entitled to it. A more recent decision, which has also dissented from the Kirby analysis, is this Fitzpatrick case out of the Southern District of New York. And it cited really three reasons why it doesn't find Kirby convincing. One is that it's fundamentally inconsistent with the rationale for the privilege. Two, that it ignores the unique and limited role of corporate representatives when they're speaking to counsel on behalf of the corporation. But I think three is really the salient point, or the one that is probably most convincing, and that's that, directors, they're entitled to deal with corporate attorneys and get all this information and this privileged information because they owe a fiduciary duty to the entity. And they shouldn't be allowed to use that right of access that they have while they also have a fiduciary responsibility in order to turn around and then use that information that they gain to harm the entity to whom they owe the fiduciary duty. And I think that's probably the most compelling argument against the Kirby analysis, and something that Kirby didn't really address in its decision. So how does Michigan deal with all of this? There is one case on point. It's almost 40 years old. It's from the Michigan Court of Appeals. It's Fasihi versus Summer Schwartz. I think that's how it's pronounced. I'm going to pronounce it Fasihi. If I'm wrong, just mentally edit it in your head so I don't drive you crazy. But in that case, the plaintiff was a director and a 50% shareholder of a medical group, and he basically got removed from the company, and he sued the corporate attorneys for helping to remove him from the company. And he had claims of breach of fiduciary duty and all of these things. But for our purposes, what is interesting is he sought discovery of communications between the law firm and the other 50% shareholder director of the medical group. And the Court of Appeals held that as a member of the board of directors, plaintiff was a member of the corporate control group. Thus, with respect to any communications defendant had with Dr. Lopez, who was the other shareholder director, while representing the corporation, as opposed to Lopez personally, plaintiff is equally entitled to this information. So this is very similar to the Kirby analysis. Rather than talk about a collective client, the court talked about a corporate control group, but the result is really the same. And what we see is that essentially one director is entitled to know everything else that another director knows with respect to attorney-client communications that occurred during the plaintiff director's tenure on the board. But we also see that doesn't include communications that would relate to the attorney's representation of the other directors personally, which raises an interesting question in terms of a shareholder oppression action. Is the corporate lawyer representing the company? Is he representing the directors personally, or both? And if so, how does that impact this decision? And I don't know the answer to that. I think it's an interesting question, but I'm not aware of any decision in Michigan that deals with that. In fact, since this case in 1981, there's been very little case law, essentially none, in Michigan state courts that I'm aware of. But fortunately for us, there have been some recent federal decisions, or unfortunately for us, as the case may be, because they don't agree with one another. One of them is a very recent case, this one out of the Eastern District of Michigan, which was just this last summer, which dealt with essentially the identical issue and held that Fasihi is controlling. So it simply applied Fasihi, said under existing Michigan case law, a former member of a corporation's board of directors is entitled to discover communications between the corporation counsel and another member of the board made during the former member's tenure. So here we have a very recent federal decision out of the Eastern District of Michigan, essentially not citing Kirby, but essentially adopting the Kirby analysis, which is the same as the Fasihi analysis. Unfortunately for us, we also have another fairly recent federal decision which did not do that. And this is the Blankenship case from 2014, also Eastern District of Michigan. There, what the court did is try to anticipate how the Michigan Supreme Court would rule on this issue, because the Michigan Supreme Court has never ruled on it. And in that process, the federal court held that the Michigan Supreme Court, A, turns to federal law when examining novel issues of privilege, and B, disfavors automatic rules and prefers tests that balance the competing interests of the parties. And what's interesting is Blankenship didn't even cite Fasihi. It's not mentioned anywhere in the case that I could see. If anyone has any insight into that, that'd be great. Maybe they can put it in the chat. I'm looking at Dan Quick in particular when I say that. But in the course of that decision, Blankenship, because it held that Michigan Supreme Court doesn't adopt automatic rules, held that the Supreme Court would not adopt either Kirby, which allows full access, or Milroy, which denies access entirely to a former director. Instead, the Blankenship court held that Michigan would adopt the reasoning of Garner, which we mentioned a few minutes ago, which is applicable to shareholder derivative cases. And again, we're going to see a little bit more of how that works, but this is, very different from both Kirby and Milroy, which have kind of these bright line rules. Blankenship would just treat a director plaintiff the same as a shareholder plaintiff in terms of their right to access attorney-client information. But before we get to shareholders, the question is now, okay, so directors have, at least in Delaware and perhaps in Michigan, directors have this right to access. What do you do if your plaintiff is still currently a director? Are they entitled to invade the attorney-client privilege in the context of a shareholder oppression case to know what the defendant is saying with his attorneys and get all of that information? Under a Milroy analysis, of course, the answer is no. They're not entitled to any of that. Again, a dissident director is not management. Management isn't entitled to any kind of attorney-client communication. And this is the rule not just in Milroy. There are other states that have adopted it. I cited one just because it's kind of a fairly recent case. But there's a number of jurisdictions, federal and state cases, that have gone the Milroy route rather than the Kirby route. But if you have a Kirby analysis, or what appears to be the Michigan rule, where directors are entitled to full access, what do you do if they're currently a director while litigation is going on? And Delaware has adopted 3 exceptions. One is that the board member can just agree he's not going to get attorney-client information. I don't know how often that occurs. I would suspect not very often at all. Number 2 is the board can form a special committee that excludes the director. That committee can then engage legal counsel, and then the committee's communications would be protected. Or 3, privileged information can be held once sufficient adversity exists that the plaintiff board member could no longer have a reasonable expectation that he was a client. And when sufficient adversity exists is going to be a case-by-case analysis. I think certainly once a shareholder oppression claim has been filed, it's probably, a pretty good bet that sufficient adversity exists, that plaintiff shouldn't be allowed to come to court and say, Judge, let me know what the defendants are discussing with their lawyer because I'm also a director too. Michigan has not looked at this issue that I'm aware of. It's not directly considered it. But interestingly, Michigan, like Delaware, does have statutes that allow for the creation of special committees. The Business Corporation Act has it, the Nonprofit Corporation Act has it, and those statutes provide for the creation of a committee and delegating powers to the committee. And then that committee has all the powers of the board with respect to whatever issue it was that was delegated to them. The LLC Act, that I'm aware of at least, doesn't have a similar provision regarding committees of managers, but 450.4404, which is the fiduciary duty section that talks about the duty of good faith and loyalty and all those things, it does make at least passing reference to committees of managers. So I would assume, at least as long as your operating agreement allows it, or at least doesn't forbid it, in the LLC context, you could do that as well. And I actually had this come up earlier this year in kind of an interesting scenario where we represented the board, we represented a nonprofit youth sports club, and it had boys teams and it had girls teams, and the girls teams wanted to split off and form their own nonprofit group and kind of go out on their own. And there was a lot of disagreement and negotiation over whether or not the club was even going to allow that, and if they did, how were the assets going to be split up, and what was going to be the arrangement going forward. And eventually they decided they would allow a split and they would arbitrate the split over, all what the terms were going to be. But the problem was the two directors on the board who kind of represented the girls teams had their own attorney that they were dealing with. But then they're also coming to board meetings where my firm is trying to advise the whole board on how to deal with these kind of dissident directors. So we, under the Nonprofit Corporation Act, we formed a separate committee of directors to handle the negotiations and the litigation of this issue. We did not hire separate counsel for the committee. Delaware law would suggest maybe you're supposed to do that, but it wasn't really cost feasible in this case to go out and add another layer of law firms. And my opinion, it never got tested in court, but my opinion is that between having a separate committee and the fact that a formal arbitration agreement had been signed and an arbitration was ongoing, that there was sufficient adversity that if you borrowed from the Delaware rule, we were probably safe in terms of protecting attorney-client privilege information that was communicated to the special committee. So that was directors. That brings us now to shareholders. If your plaintiff is just a shareholder but not a director, what right do they have, if any, to invade the attorney-client privilege between the attorney for the corporation and the directors and managers? And this Garner is the case I mentioned a couple times already. That was a shareholder derivative action. So the plaintiff was suing on behalf of all the shareholders as a class, not just for himself. And there the court held that this idea of the entity being separate from the shareholders is not really a useful tool of analysis, because at the end of the day, the management's duties run to the stockholders. So at a certain level of abstraction, or if you take enough steps back, the shareholders are, in a sense, the client of the attorney for the corporation. So this is kind of similar to this idea of a joint client that we saw in Kirby, just not expressed exactly the same way, but you see the idea kind of floating around in the background there. And so what Garner held is that the shareholders may show good cause why the privilege should not be invoked. And so what is good cause? Garner set forth 9 factors to be considered. I'm not going to read all this to you. We're not going to go through them. They're just there. I'll give everyone a second to write down the site. It's 430 F. 2nd 1093, the Fifth Circuit opinion, 1970. Going once, twice, 3 times, okay. So unsurprisingly, Milroy, which we have seen twice now, I think, it wasn't a fan of the Kirby analysis with respect to directors. It's also not a fan of the fiduciary exception with respect to shareholders seeking information. And again, it went back to this issue of management. It relied primarily on US Supreme Court cases, Upjohn and Weintraub, and pointed out that, again, the critical issue is management. The attorney-client privilege sort of travels with whoever the managers are at a given time. And individual shareholders or shareholders as a class aren't managers of a corporation typically. And so therefore, they don't have any right to invade the attorney-client privilege. What Milroy also pointed out, though, is that even if Garner is going to apply, the rationale really only applies in a derivative claim where the shareholder is suing for all the shareholders as a class. It doesn't apply where the shareholder is asserting claims primarily to benefit himself, especially if that's going to harm the other shareholders, which is quite often the case in an oppression claim. Typically, there's one or two plaintiff shareholders that are suing to get a remedy for themselves, typically a buyout. And this is money that's going to go to the plaintiff. And every dollar that goes to the plaintiff is one less dollar in the hands of the other shareholders. So it's not something that's going to benefit all shareholders on a pro rata basis as a shareholder derivative claim is supposed to do. Delaware in this context follows Garner. We saw Kirby right at the beginning adopted Garner. More recently, the Delaware Supreme Court has adopted the Garner rule in shareholder cases. So what the rule is in Delaware is pretty clear. In Michigan, it's not clear at all. There isn't really Michigan's published state court opinions on point that I'm aware of. There are some interesting federal decisions out of the Sixth Circuit. In Re Rosbach security litigation, that's a Western District of Michigan case from 1991. That case adopted the Garner good cause analysis in a securities fraud case. Fausick versus White, which is a Sixth Circuit opinion, adopted the Garner analysis in a shareholder squeeze-out case. And that was a case that came out of Tennessee, so it wasn't brought under the Michigan shareholder oppression law, but it was very much an oppression type case. It had things like failure to pay dividends and managers paying themselves excess salary and plaintiff not being given any information and all these sort of typical things we see in shareholder cases. And there the Sixth Circuit applied the Garner rationale. And it noted the issue we just talked about, that in these cases, the plaintiff is typically seeking a recovery just for themselves, not for all the other shareholders as a class. But at least the Sixth Circuit concluded that really only makes their motives more suspect, and that's one factor to be considered, but it's just one among the 9 factors that would ordinarily be considered. And there, the Sixth Circuit said, notwithstanding that, it applied Garner, it found good cause to allow the shareholders to discover what would otherwise be attorney-client information. So then that brings us to LLCs. LLCs are kind of simple because we've already talked about it in the shareholder context, and in Delaware at least, they just treat LLCs the same as corporations. So they've applied the Kirby analysis to managers of an LLC, in effect treating managers the same as directors, and they've applied the Garner analysis to members of an LLC, in effect treating members the same as shareholders. So then what's the answer in Michigan? There's one decision on point, Huey versus Mahar. It's an unpublished decision. It's wrong. Don't cite it, unless it helps you to, but just know that it's wrong. There, the member was a 49% member, was not a managing member, and the court, citing Fasihi, said, as a member of the LLC, plaintiff is entitled to information from either attorney about the representation of the LLC. That's not correct, or at least if it is correct, it's not what Fasihi held. Fasihi was based on the plaintiff being a director. A minority member who is not a manager or a managing member is not analogous to a director. So I don't think that that's the correct decision. That's it. I know someone asked in the comments if they can get the slides. That's my email address right there. If anyone wants to email me for the slides, I'm happy to send them. I ask that you wait a day or two. I don't know if the bar is going to send out all these slides. So wait to see if you get it from somewhere else before everyone just starts inundating me with requests. But otherwise, I'm happy to share them. And that's it. And thank you.
And a very special thank you to you, Mr. Hansma.
this ever-changing world.